Hi, my name is Steve Baicker-McKee. I'm an assistant professor at Duquesne University School of Law. My research and my area of practice is civil procedure, and more specifically discovery. I have a long background in practice. I practiced for almost 25 years before becoming a professor, and so I'm trying to bring that practical experience to bear in my research. And so I've focused my research on discovery. My current topic that I'm looking into are the recent proposed amendments to the Federal Rules of Civil Procedure, and specifically the discovery rules. These are the most dramatic amendments to discovery since 1993, when the automatic disclosures were added. And what the rules are doing is, for the first time, instead of expanding discovery, like we've done for years and years, the rules are retracting the scope of discovery in these amendments. And so the very definition of what's discoverable is being changed. It used to be anything that was related to a claim or defense in the case that was reasonably likely to lead to the discovery of admissible evidence. Now they will add the concept of proportionality. So it has to be balanced. The value of the discovery has to justify the burden or the cost on the responding party. They are reducing the number of all of the techniques that you can use. So the number of interrogatories is going from 25 down to 15, number of depositions from 10 to 5, and they are also adding a uniform sanction provision relating to the loss of evidence or spoliation of evidence. So what's interesting is, for years and years we've seen the scope of discovery expand, and now with the explosion of e-discovery and the cost of all of this e-discovery, which costs millions of dollars. Individual cases can cost millions of dollars just in e-discovery. The courts are reacting to that and saying that defendants are sometimes paying large amounts of money to settle meritless cases, worthless cases, frivolous cases, in order to avoid these enormous costs. And so the pendulum may have swung too far, and the Rules Committee is now looking for the first time at retracting the scope of discovery in response to this phenomenon. And so what I'm doing at a time where there's a potential to influence these amendments, is commenting and writing an article during the process before they get to Congress, so that I have the potential at least to influence that process.